the court did not provide a copy to the defense counsel, as it should have done. So therefore, it goes on. This is their word. Notice, blah, 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 blah. The public access challenge was thus pending and litigated as the trial approached and proceeded, and the state was on notice of it, while the defense was left unaware that a member of the public was contesting the very closure at issue, and that the state knew of it, while the defense did not. Both corroborate that the closure was real and confirm that the defendant had no opportunity to litigate it or object to it as it unfolded. Then wait for the whammy. The record of that proceeding is, moreover, among the materials in the court's file that the court has placed under an oral protective order. So that the proof of who was and was not notified is itself withheld from inspection, a further reason that these facts must be developed at a hearing. So I do plan to be there on the 20th. If the court should have any questions for me, I'm like, yeah, Your Honor, talking about me. You know, and the case I cited, now we can go into the importance of the case law. The granddaddy is Waller versus Georgia. And that tells people that it describes that if you're going to have a closure of any kind, you've got to have what's called a compelling governmental interest. This is what's called a strict scrutiny analysis. You are messing with fundamental rights, not just. So I wrote my brief from a perspective of the public First Amendment access right, but there's an attendant Sixth Amendment right to a fair trial, all right, and a public trial that the defendant has. The defendant did not ask for a closed trial. Sometimes defendants do, if it's really gory or whatever. They didn't ask for that. The state did it on its own. That makes it very different. So now,
King Cass,
yes.
what are the top 3 things that you think will allow this case to possibly get a retrial? What are some of the top 3? What is the top 3 things that you think will open the door for a retrial for this case?
Okay, let's wrap up with number 1, which is what we're discussing right now, the closed court.
Okay.
So there was a case. Let's talk about these cases here. There's a table I just had pulled up. Hold on. And the table goes through these cases that describe what happened when you have a closed court and how the case was decided in terms of whether it be a new trial or not, right? So, I'll be dead. I can't find it right now. But the cases themselves go through it. It's called structural failure. I'll describe it to you, okay? And if you have here it is. I got it right here. Waller versus Georgia is number 1. Okay, was there an overflow room or a live remote feed available? Okay, so when you have this compelling governmental interest, first you have to have a hearing on the record to define what is the compelling governmental interest that you're concerned about, right? Because I cited about 7 different cases that were huge, notorious cases that were handled with public access, with overflow rooms, with TV, all of these things, right? Carmelo's case was nothing new. So, except for the level of cover-up, in my opinion. But so Waller versus Georgia mandates a hearing on the record with findings of fact and conclusions of law as to what is the compelling level of interest to make it so narrow that you can only have this handful of people come in. That hearing never happened. Furthermore, when you're doing it, it has to be narrowly tailored to approach that objective. There's no fighting about that. There were other ways that could have accommodated this, like an overflow room, considering the fact that they used one for the voir dire jury selection. None of this makes sense. So, what happened in Waller, the entire suppression hearing was closed.